Welcome to Aging Insight with your host, John Ross and Lisa Schollmeyer. This program is made possible by
Welcome to another edition of Aging Insight. I'm John Ross here with Lisa Schollmeyer, and we're going to have a pretty interesting topic for you, one that comes up a lot. But we do this program to bring you that good information, try to answer the questions you have out there. We get questions all day long, every day from actual clients, and that kind of gives us an idea of the information that is needed out there in the community. And that way, when we get an opportunity to come into the studio and do a little TV recording, we know what kind of information you probably want to know about, and that's why we do the show.
That's right. Well, John, there's we're elder law attorneys, but in part of our practice includes preparing wills, probating wills, helping families deal with property and things like that after the death of a loved one. And that's all very technical stuff because we're dealing with money and real estate titles and then sentimental items. And families.
Yeah, absolutely.
So which we really enjoy doing that, but we often, John, I know it's hard to believe, but not every family is just a lovey-dovey, all on the same page kind of family.
Not everybody gets along.
Yes.
Unfortunately, they don't always get along, and particularly when somebody has died, when there has been a loss. A lot of times the tensions are high, the emotions are high, and old wounds get reopened, and you get some anger in all of that, and some of that can be compounded once people get an idea of how assets are going to pass at death.
Right. So, so we're lawyers. We're not psychologists or counselors.
Nope.
So the emotions running high and all that stuff, maybe we should get Dr. Phil on here to talk about that. But what we're going to talk about today is what happens when someone in the family threatens to contest a will, or if maybe you believe that the will is not what you expected it to be and you are trying to decide whether or not to contest a will. So we're going to talk about the very drama-filled area of will contests today.
That's exactly right. So first things first, I saw an article, is actually in the news this morning, and it was from somebody that said, my stepfather has not probated my mom's will, and it's been 6 years, and he hasn't done anything, and I've seen the will, and it left half of everything to the kids, but he hasn't done anything about it. And then the person that was answering this, kind of a Dear Abby sort of thing, basically got everything wrong after that. So no point in going into everything that they were saying, but here's my guess of what happened in that situation. Everything the couple had was probably things like bank accounts that were in both of their names, investment accounts that were in both of their names. Maybe this person's mom had a retirement account or an IRA or something like that she had named the husband as a beneficiary on. And it's possible, I don't even know what state this was in, but let's say that they lived in a state like Arkansas where real estate that is owned by a husband and wife passes to the surviving spouse automatically, whether or not the person has a will. And so it would not surprise me at all, Lisa, that the reason he has not probated the will in this case is because there's no need to. Everything passed to him outside of the will and outside of the probate process. So whether this this young lady wants to challenge the will or force it to be probated, or it gets it probated, none of that is going to change the fact that everything passed to him outside of the will.
Right, and that is an area of confusion, because many people, if they've never been through this process before with the death of a loved one, all they know is maybe what they've seen in the movies. And all they know is in the movies, you know, when someone dies and there's property, there's a reading of the will, and there's an attorney, and there's this, you know, you may go to the courthouse. But in many, many estates, that's not required. And so the situation you were just describing could very well be that situation where there was no need, there was no necessity to probate a will. So if you are the person thinking that things aren't right, and I might jump in here and force a will probate or file a will contest, first thing you need to figure out is, are there any assets that would even be governed by a will? Because if not, then you're just throwing your money away by filing a contest or probating a will that doesn't need to be probated.
That's right. All right, we're going to take a quick break. We're going to come back and talk some more about what you do if you do actually want to contest the will. So stick around.
Oh, so luxurious, but just a little too soft. Just a little too hard. This one's just right.
Welcome back, everyone, to Aging Insight. I'm Lisa Scholmeyer here with John Ross. And today we're talking about a topic that a lot of people ask about, but it's very dramatic. It's about will contests.
Yeah, we just went and saw a movie about it the other day.
That's true, we did. They still make Hollywood movies about will contests. So there's plenty of drama. So in our first segment, we talked about in many estates, there's no need to probate a will at all. So there's no will contest to be had in such a case. But John, let's go back to the more traditional estates that people think about, and that there's land, there's money, cars. Maybe we even have, sometimes it can be a blended family where, you know, it's step parents. It can even be a intact family, but maybe one of the kids is kind of a black sheep, and, you know, mom and dad didn't like them too much, or so family dynamics and personalities absolutely come into play. But what happens most often when someone dies, now remember, a will means nothing. It doesn't mean a thing until a person is deceased that has made that will, and it is determined that that will needs to be probated and taken to the courthouse and entered into the probate process. Until those two things happen, there's no will contest to be had. You certainly don't contest a will prior to someone's death, because as long as you're living, you can change your will at any time. So it's not set in stone. But let's say that we are in a situation where a will has been offered for probate at the courthouse, or is anticipated to be offered, and the provisions in that will cut you out. Okay, John. So now we have a family member who may be a what we call a natural heir, perhaps a child, who maybe that parent has cut out of the will, or sometimes I'll see that they leave them a very little amount.
Right, a disproportionate distribution
Yes.
in some way, shape, or form. So yeah, if you're wanting to contest it, you can, first of all, you got to figure out what are your options. Well, the first thing, and you know, when I'm analyzing, somebody comes in and they say, you know, here's this will, I want to get this will probated. or I want to contest this will, or whatever it is. But if it relates to the will, the first thing somebody like me is looking at is to determine, is it actually a valid will? You know, in order to be a valid will, it's got to have certain formalities. You know, was it, for example, a holographic will, meaning that it was entirely in the person's own handwriting and signed? And when I say entirely, I mean entirely. So if the person went and got one of those little fill-in-the-blank forms, and in their handwriting they filled in the blanks, but the rest of the document was typed, well, that's not a valid holographic will. It's not entirely in their own handwriting, in which case there is no will to contest because the will's invalid. Or maybe if it's not a holographic will, it's got to have two independent witnesses, and those two witnesses, if it's a Texas will, have to be 14 years or older at the time they sign the will, or if it's an Arkansas will, they've got to be 18 years or older. So the next thing I'm looking at is, you know, if it's not a holographic will, was it signed in the presence of two witnesses? Were those independent witnesses? And so, you know, just some of these basic formalities. In fact, one of those basic formalities is it even a will?
Right. You know, a will is a document where the document on its face is contemplating the death of the testator. You know, upon my death, I want this property to go to these people. That's a will.
Right.
But just a list that has John pickup truck, Lisa pearl necklace, that's just a list.
That's
it's
just
not a will.
That's right. It lacks what we call testamentary intent. It's not obvious from the document that was intended to be a will. Those could have been lifetime transfers. They could have just been a list of things that people have said they wanted. Who knows? But it's not actually a will. So the first thing you have to determine is this actually a will? If you get past that, though, then you're going to have to find another way. So if on its face it looks like a valid will, but you still want to make it invalid.
Right, that you would like that will to be thrown out.
That's right. You're going to have a reason for it. And generally, that reason is going to come down to a lack of testamentary capacity.
Yes, or that's one reason. The other reason is undue influence. So I guess we'll kind of take these one at a time, John. But, you know, when you make a will, you have to have sufficient mental capacity to know what you're doing, to know that you are contemplating death, and you want this document to reflect that these are the beneficiaries. You want to receive your property. You also have to know who the natural heirs of your bounty are. That's a kind of an old phrase, but it just means you know who your family members are. You know who your friends and those closest to you are. Also, you have to know what property you actually own and that you actually have, and you know what debts you might owe. By knowing all of these different things, the law presumes that if you know these things and you complete a document that purports to give away the property that you own to the heirs and beneficiaries you select, in a document that contemplates that when I die, I want this to happen, that is testamentary capacity. And many people in a will contest, a common challenge is that the testator, the person who made the will, didn't understand all of those things when this will was made. And John, that testamentary capacity, or the lack of it, can be a very tough claim to show.
It is. It's very difficult because you're often going back in time to some time when they executed that will, and you're showing that they lacked one or more of those three things: the ability to know who their people are, to know what their stuff is, and to hold all of that information in their mind long enough to make that document. and proving that that was the circumstance a decade ago
Right.
can be very difficult. And so that is a very high bar to get over if you want to prove that that person is incapacitated. It can be done, but you've got to have some pretty good facts.
Yeah, if you're the one that wants to contest that will and have it thrown out and you didn't think mom had testamentary capacity, then the burden is on you to show that, to bring evidence that mom lacked testamentary capacity at the time she made the will. So you're going to have to do a lot of digging. That may include digging into medical records, talking to witnesses. Can be an expensive litigation process. And also, the more time has gone by, the more difficult that is to prove. So
That's right. The other one is undue influence, and we'll talk about that one as soon as we come back from this break. Stick around.
I'm so glad we found the Wadley Senior Clinic. Their team specializes in caring for older adults, and their doctors listen and work with me to keep me healthy and independent. With monthly educational programs, x-ray and lab, and state-of-the-art exam rooms, I get expert care and understanding about what I'm going through. Best yet, they're easy to get to right off the interstate at Jefferson. See what Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back to Aging Insight, everybody. I'm John Ross here with Lisa Schulmeyer. Today we're talking about will contests, and kind of from the standpoint of if you want to contest a will, what are your ways? Is it even a will at all? Does it meet the basic requirements for a will? Because if it doesn't have the right signatures or things like that, then it doesn't matter if the person made it out or not. It's out.
that's right.
The person had to have the mental capacity to understand what it was that they're doing, although that's very difficult to prove, especially if it was done many, many years ago. The last one, and one that we actually hear probably the most often, is the claim of undue influence. And basically what this means is that somebody pressured this person to such an extent that they overrode their free will, and so this will that they signed, they were not under their own free will when they did it.
Right.
They were under such duress that they had no real choice but to sign the will. And the classic example of this is, the holding the gun to somebody's head and saying, if you don't sign the will, I'm going to pull the trigger.
Right. And
Right? That will's invalid.
certainly. I've never had that case come up.
No.
But that is the example of how that law professors often describe how extreme the pressure has to be on someone to prove a claim of undue influence. So if you're trying to throw out the will and it appears to be a valid document on its face, you know that 10 years ago when mom wrote the will, you don't have any good claims that she lacked capacity. But if the will says your sister gets everything, and you feel in your heart that your mom loved you too,
Right.
and that mom would never have cut you out of the will but for your sister's exerting her influence on your mother. That is a claim for undue influence. But John, the law makes it very difficult to prove, because what we hear most often from someone is, well, I got married, I moved to Little Rock, my sister, she never married, she bought a house right next door to mom, and she was there morning, noon, and night, and I would visit for holidays and all, but I know that my sister just really bad-mouthed me and made it to where she told all these lies to my mother about how I didn't care about her, and because of those lies that my sister told to my mother wrote me out of this will, or she left me very little, and I want to contest this will because if my sister hadn't been there always talking in her ear, she wouldn't have done that. John, is that an undue influence case?
No. Is it influence? Yes. But did that influence rise to the level that it overrode the free will of mom? And the fact is, lying to mom doesn't get you there. In fact, even things that might seem like undue influence, actual stories that we have heard and have been told, for example, where the kid says, if you don't sign this will, mom, or if you don't give me the house in the will, or if you don't leave me everything in the will, then I'm not going to bring the grandchildren to see you anymore. Is that influence? Yes. Is it undue influence? I mean, was mom still perfectly capable of hauling her cookies up to a lawyer's office and doing a will in any way, shape, or form she wanted? She sure was. Maybe she made a choice that the access to the grandkids was more important to her than some will contest after she was dead. But she still retained the free will. Was that dirty? Was that
right? Is it completely distasteful and unethical and despicable? Yes.
Absolutely. Is it undue influence? Probably not. Now, there's some things though. What if that kid, you use the sister that's there with mom, and what if the sister that's there with mom, she's the one that's taking care of mom in the home, and she's telling these lies about the sister. Oh, she doesn't care about you. She never comes and sees you. I'm here all the time. That's probably not undue influence. But what if she says, and if you don't do this, I'm going to put you in a nursing home.
Ah, okay. So.
And maybe mom has always professed that one of her greatest fears was to be in a nursing home. Yeah. She had seen her mother in a nursing home and had a very bad experience with it. And this is something that she's always fretted about. Right. And now this sister, not only is she lying and doing these other things, but now it's, if you don't do this, I'm going to make your worst fear come true.
Right.
So I'm going to put you in that nursing home. And we've heard these stories before as well.
Yes.
That, I think, is probably going to rise to the level of not just influence, but undue influence.
But John, with all of these things you're saying, oftentimes that influence is exerted in private.
That's exactly right.
So if you're the sister that's been written out of the will, and you know in your heart that it's because of your siblings, what they've done, you've got to prove to the court that these things happened, that your sibling threatened to put mom in a nursing home if she didn't sign this will. And that, too, can be very difficult.
That's right. So, generally speaking, it is very, very hard to contest a will. Despite what you see in Hollywood and all of these sort of things, the actual process of contesting a will is very difficult. It's also very expensive. Because it's going to take a lot of time developing this evidence, and particularly if you're talking about going to trial and all of these other things. That's a very, very expensive process, and if you're the one wanting to do the contesting, it's expensive and a gamble. Right. And not a gamble with great odds, because it's hard to prove whether or not mom was lacked mental capacity a decade ago.
Right.
Or that your sister, in private, where nobody else heard it, threatened mom to a level that rose to undue influence. So all of that stuff's very difficult, very hard to prove, which all goes back to the point of, get your stuff in order. People like us, when we anticipate a future contest, there are things we know how to do to make it much more difficult to contest it later on. So if you're expecting a contest, get in touch. If you're the one who wants to contest it, if you want to know what your options are, we could answer that too. So anyway, we appreciate you watching the show today. If you've got other information that you want, you can always pick up a copy of the Aging Insight magazine. listen to our radio show, Aging Insight, live every Saturday on 107.1, or you can just stick around next week for another episode of Aging Insight. Bye-bye.
Bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Schollmeyer. This program is made possible by